Misuse of corporate information. So, if the director exploits any unpublished information of the company may claim compensation from the director for the loss or the damage. The duty of directors is both ethical and legal, which requires them to make decisions in good faith. A faithful director is not enough. A director must work with reasonable care and duty. If the director is negligent, the work assigned to the director must be done with due caution and care. If a director is negligent, he must be liable for the loss caused to the company. Liability for not attendance. A director is not bound to attend all the meetings of a company and pay continuous attention to the affairs of the company. The directors of the company have their right to exercise their powers in the meetings of the company under Section 285. So, what is a quorum in a company? So, quorum of the board is 1/3 of its total strength, or 2 members of the company, or 2 directors, whichever is higher. For example, a company has 15 directors and 6 directors are there. So, either 1/3 of 6 directors or the meeting of 2 directors will be valid. Register of directors. Every company must contain a register which contains the particulars of the directors. The register must be maintained within 30 days of the appointment of the director. For shareholders also, the company needs to maintain a register in which the particulars like the name or address or anything which is important for the company should maintain the information in the register. So, the directors can take loans from the company, but there are some restrictions in which the directors cannot take loan. So, remuneration of directors. Section 309 states the remuneration to directors, which is either described in the Articles of Association or it is discussed in the